okei, tõusen püsti või? Tõusen püsti või? Okay, hi everyone. Good afternoon. Welcome to the defense of Pawan Kumar Dutt on the topic of intellectual property as an element of the public support system for small and medium enterprises. I will now introduce the agenda and the procedure of today's defense. I will first introduce the committee members. First, here I have Frantzeska Papadopoulou, who is the professor of intellectual property law at Stockholm University. And she says herself that she has a special interest for pharmaceutical patents and regulatory rights and Swedish film rights. She defended her thesis in 2014, where she focused on the protection of traditional knowledge and genetic resources under the framework of international intellectual property rights regime. And she has experience both as a practitioner and as an academic, as she was an in-house lawyer at the Swedish Association of Industries for 8 years, with a focus of intellectual property and contracts. And she's particularly interested in how technology influences the evolution of the management of rights, as well as the evolution of the legal system as a whole. So I'm very happy to have you here. Thank you. And secondly, we have Mervi Raudsaar here, who is an associate professor of entrepreneurship who works at Tartu University at the School of Economics and Business Administration, where she is the head of the chair of entrepreneurship. She received her PhD from Tartu University in 2016, where she focused on the developments of social entrepreneurship in Estonia. She publishes on social entrepreneurship and entrepreneurial competencies, among other topics, and is also actively leading and participating both in Estonian and European projects. So thank you for coming here. And lastly, I am the head of the committee, Regina Erlenheim, Vice Rector for Research at the Estonian Business School. With the focus of my research is on e-governance and public service design. We are also joined here by Pawan's supervisors, Adjunct Professor Katrin Nyman-Metcalf of Tallinn, and Professor Tiit Elenurm of Estonian Business School. So welcome and thank you for being here. Shortly, Pawan will give his presentation of 20 minutes. But before that, I will give the word to the secretary in a second. The secretary of the committee is Sigrid Laineve, who will give a brief overview of the administrative state of affairs. After Pawan has presented the core of his PhD work, the opponents will be given the opportunity to ask questions and lead an academic debate on the topic. Questions from the floor and from online will follow suit. The final word will be given to the supervisors after everybody else has spoken. And after that, the committee will break for voting. So thank you very much for being here, physically and online. And please, Sigrid.
Thank you. Honorable Chairperson of the committee, members of the committee, supervisors, and the defendant. Pawan Kumar Dutt has presented all the documents that are necessary according to the procedure for successful completion of the doctoral program and defense of EBS. Pawan Kumar Dutt has presented the thesis titled Intellectual Property as an Element of the Public Support System for Small and Medium Enterprises. The set of documents which Pawan Kumar Dutt has presented also contains a copy of his master's diploma from the Tallinn Technical University. Pawan Kumar Dutt has fulfilled the requirements of the curriculum of doctoral studies in management to defend the doctoral thesis and acquired the necessary amount of credit points. On November 14th, 2023, the EBS Senate Research and Development Committee admitted Pawan Kumar Dutt to defend the dissertation for the degree of Doctor of Philosophy in Management. The committee also set the date of the defense. The defense committee of Pawan Kumar Dutt doctoral thesis was confirmed with the rector's degree number 12U on December 13th, 2023. Pawan Kumar Dutt has presented his academic CV, and it is the following. Pawan Kumar Dutt was born in February 28, 1975. He has passed the 2 years MA course in law cum laude from Tallinn Law School of Tallinn Technical University in 2010. He has passed the Bombay University LLB examination from Government Law College, Mumbai, India in 1998. He has passed the Bombay University Bachelor of Science in Chemistry examination from St. Xavier College, Mumbai, India in 1995. Other qualifications, Pawan Kumar Dutt has passed the Patent Agent examination conducted by the Indian Patent Office in 2006 and the Articled Clerks examination conducted by the Bombay Incorporated Law Society, Mumbai, India to qualify as a solicitor in April 2002. Pawan Kumar Dutt was enrolled as a doctoral student at the Estonian Business School in 2013 and has by now completed the program. Since 2011, he has been working as a lecturer at Tallinn University of Technology, School of Business and Governance, Department of Law. In Tallinn Technical University, he has been nominated as a Lecturer of the Year several times, last in 2023. By Estonian Science Infosystem, Pawan Kumar Dutt has 19 publications and completed 6 research projects. Thank you.
Please, Pawan.
Dear committee members, thank you for giving me this opportunity. And well, my thesis is, of course, on intellectual property as an element of the public support system for small and medium enterprises. And it's been a long course, 6 articles, and this umbrella article. And the focus, of course, has been on sustainable economic development and the sustainable development goals. The motivation came, well, from my experiences, both as a lawyer and an academic. And, well, this has also influenced the choice of the countries, the topic, of course, and the theoretical model, besides various other aspects. The research gap that was looked at over here basically tries to mold together the legal and, well, the business aspects. And so we're looking at the European Union legal framework for IPR and whether it exclusively influences the possibility of the public support system for SMEs. And since I've been living in Estonia for a very long time, it's obvious that I have focused more from the Estonian viewpoint within the European Union. The research problem goes into the question of whether public support systems in Estonia can help SMEs to attain, expand, and exploit their IPR portfolio in a sustainable manner. This has led to the research questions, and, well, there are quite a few of them. On the first level would be the theoretical aspects. These were issues that have been both enriching and at the same time complicated, because finding the right theoretical approach can be an issue sometimes. Given my background, I would have presumed that IPR and RDI would lead to a simple solution of using intellectual property law theories as the most obvious approach. However, that is not the case as it seems. So that's why we have looked at why IP law might be insufficient by itself, and then the social systems capital and how these work in the context of a theoretical background when it comes to looking at how sustainable RDI laws and policies can be framed. And of course, this is not a law thesis. I must stress upon that every time. Research question 2 went into support measures of more advanced EU economies, and this is always tricky because comparative analysis can lead to wonderful viewpoints or the Waterloo. But I have published several articles. Hopefully, they make sense in this regard. Research question 3 goes into the designing of sustainable public support measures and what sort of legal background would play a role here. But again, in the background. It is not a law thesis. And lastly, we have looked at the unitary patent system. This is something that is quite close to my heart because it is as delayed as my thesis has been. I'll go into this in more detail. Here's the overview of the dissertation. And, well, the research questions come together. At the center is, of course, the 4S model. And when we look at the 4S model as a starting point, which I will look and explain in more detail soon, we see how research questions 1 regarding the theoretical aspects and 2 regarding the comparative aspects give rise to certain attributes which are part of the framework. Similarly, comparative and legal issues give rise to what would be the legal approach that comes up over here. And similarly, with theoretical and state aid rule aspects, we have the new framework and benefits of the unitary patent system. So regarding research questions 1, 1A, and 1B, the starting point is, of course, Parsons. And, well, this is a tricky situation because what Parsons proposed in 1951 was already the grand theory, and he has had a lot of pros and cons regarding this. Well, basically, you're talking about individual actors who interact with each other within a particular environment and who have motivations which are cloaked within cultural and other symbolic aspects. Now, this theory, grand theory by itself, does not lend automatically to IP as such, but through my studies in EBS, I came across the works of Groen et al., and I've been very influenced by these works, and in 2002, they proposed a particular social system based on the Parsons ideas. And the main aspect over here are the issues regarding how cultural, economic, social, and strategic capitals play a role in combination. This is the starting point, and I hope to showcase the evolution of the theoretical issues here. So this is the starting point of the diagram, and then, of course, it talks about the 4S model comprising of skills, social networking, scope, and scale. These are, of course, the words for cultural, economic, social, and strategic capitals, and how they help or influence the system by influencing the participants within the system. This was then combined with the concept of entrepreneurial opportunities. And as you can see over here, Shane and Venkatraman have proposed certain aspects regarding recognition, preparation, and exploitation of opportunities. And this was the next logical step where the 4 capitals were combined. But this led to some questions which were left unanswered. Basically, it's very simple to talk about capitals, but what are the various attributes that go into them? Based on the research, the comparative research, the analysis, I, as the author, came up with certain attributes, and 19 of them are listed in this particular diagram over here. And there's, of course, Table 5 in Appendix 1, which goes into much, much more greater detail. We combined SDGs, legal aspects, a lot of the theoretical aspects, and look into various issues that combine over here. As you can see from this particular diagram, there are some attributes which have common grounds with some of the capitals. Coming to the next issue was how can this be improved? And so the opportunity was taken, which the next slide would show with regard to improvement of the framework. For a long time, I had this question whether what I'm doing is logical by itself and does it cover everything. But the new Estonian RDIE strategy showcased certain aspects which are very interesting, and also the stress upon the 4 capitals. And this actually helped me understand that I really am on the right track because the similar background has been looked into from both sides, my side and the Estonian government side concurrently. The improved framework is here, and of course, it talks about combining the ideas of Parson and Groen and looking at value creation, not wealth creation, and the context of the knowledge and innovation-based enterprise as such. During the course of this work, various theoretical approaches were looked into, and they are outlined over here. And this sort of led me to the conclusion that, yes, the social systems theory is the best approach in this regard. Regarding research question 2, there was this comparative analysis. Number 1, we looked at triadic patents as a measure of international IPR. And then, of course, this led to the question of what can be the outcome with regard to ranking systems. So a ranking system was developed over here. And then, of course, it outlines certain aspects which then came out in the context of the results. The RDIE strategy of Estonia also similarly looks at this issue, and so some common questions regarding measuring productivity and propensity and other aspects which are the relevant factors are sought to be explained by this thesis work. When we compare Estonia with Finland and Germany, certain aspects do come out over here. Each of these were part of an individual article, so you can see how this was looked into in great detail. And with regard to Finland and also with regard to Germany, it's quite clear that there's a lot of emphasis on the public support system for RDI networks and universities and cooperation and networking within and outside these individual countries are stressed upon in both situations. And in this regard, certain specified instruments and strategies were outlined, which have also now been incorporated within the context of Estonia. And here the unitary patent has been shown to be of use. There were interviews with Estonian stakeholders, experts, and SMEs. And well, I can leave this slide for more discussion later on. But yes, one of the issues that came up was the popularity of comparing Estonia with Finland, and surprisingly also Israel. And various inputs were provided by the experts. As far as the SMEs were concerned, the similar questions do arise all the time: financial costs, ineffectiveness of IPR, negative mindset of society, aversion to closed societies with monopolistic IPR, and non-cooperation from the state being some of the usual gripes in this regard. Simultaneously, it could be seen that similar findings are also outlined by the IP SME scoreboards, which are organized by the European Union Intellectual Property Office every 4 years, and I've looked at the last 4 of them, and as well as the new Estonian RDIE strategy. With regard to questions 3 and 3A, well, the European Union competition laws and state aid laws were analyzed, and well, although market failures by themselves are the motivating factor, there are other issues as well which require state aid in the context of RDI. And the issues that were dealt with were regarding how much RDI is legally permissible, but again, not from a purely legal format, but rather from a business viewpoint and from the public support viewpoint. At the same time, a cost-benefit analysis of the unitary patent and the unified patent court also shows that it is an effective international IP system, not only for the purposes of ranking, but also for propagation of RDI support strategies. The main findings that can be seen here, number 1, are that IP law-related theories by themselves as well as organizational theories are just not sufficient. And the social systems theory and Groen's 4S model enables a more all-rounded approach with regard to SDG attainment and also dealing with IP and anti-competition, or rather antitrust issues. The relevance of the ranking system has been reinforced over here. Comparative analysis of Estonia with other countries has shown the institutionalized public support and how it can be helpful as a RDI policy. The requirements of the Estonian stakeholders have been looked into in this regard as well, and how certain help can be useful with regard to RDI exploitation in the Estonian SME context. Also looked in over here were the relevant EU requirements and how the principles of state aid in a social context have a lot of things in common with the 4S model of Groen and the strategic, social, economic, and cultural, along with motivational aspects and the utility thereof. Contributions to the field of management research would be over here, namely the explanation of the role of the public support system to help SMEs in the context of exploiting their IPR portfolio, a customized framework which enables to understand key attributes, and also the relevance of IPR in high technology fields. This has been an issue which has bedeviled me a lot, because it's very common for a lot of people to consider that IPR may not be entirely relevant, although that is not the case, as the published articles show. The various key attributes have been also tested in a rather limited context, but nonetheless, yes, have been tested. And the econometric analysis of triadic patent statistics has also been utilized and has been shown to be a successful methodology aspect. Along with this, the European Union legal framework has been looked at, not in detail, but nonetheless has been examined, and the unitary patent system has been brought up in its utility aspects as well. And it's hoped that the new Estonian RDI policy can benefit from some of the recommendations over here, just as the transfer technology offices of various EU public universities and SMEs in various member states. As far as recommendations are concerned, yes, countries in the European Union need to adopt a more coordinated approach. The percentage of the GDP spent on RDI needs to be above a certain level, which can be challenging in the context of how the budget in many countries tends to be. Focus on science, technology, engineering, and maths. And of course, also the issue of commercially viable, result-oriented RDI with a focus on IP generation and exploitation, along with increased collaboration between various actors. Some of the steps that are outlined here are already in focus, are working out, but of course this research has been going on for 11 years, so a lot has changed in the meantime. Coming to limitations, well, there's a long list of them, not out of humility, but of course it is a frank admission over here. Teaching IPR has also revealed to me a lot of things, and a lot of people don't see IPR perhaps the way as I do. I think I'm a bit over-passionate about IPR and even about patents. My work also, besides in the university, deals with copyright issues and various other aspects. Growing up in India, I've seen how IPR has overtaken various other aspects of life and how the IP regime has become so strong. But yes, this is a strong limitation. It can put off a lot of people sometimes when I talk so much about these issues, especially patents. Theoretical aspects, well, 11 years down the line, I would think I have it right, but theories, well, everybody has their own pet theories, and I found out mine. There are 3 more articles coming out next month on the same lines, so I think if Mr. Groen meets me, he will be happy if nobody else is. The 19 key attributes, well, the question is why 19? Why not more? Why not less? What's the magic number? I have tried to figure them out as best as I can and tested them as well with mixed results. The methodology, of course, has been, well, always questionable, along with the literature review, because we are all from different backgrounds. And well, although the emphasis was on publishing in peer-reviewed and reputed journals, that does not always take care of the aspect of peer review in the literal sense, although it has been my endeavor here. And lastly, the unitary patent regime has suffered from many false starts and political infighting in the European Union. I mean, anybody who knows about how this has been going on has seen it has been a disaster train wreck, and everything has pumped in one way or the other, Brexit and COVID and so many things, and also transnational issues within the European Union. So is the unitary patent the right thing to put my bets on? Well, the latest outlook does show that it has been on the right track. So I thank you for your time, and I must confess I sort of lost track during my little talk here, so I hope I am within time, and if not, please forgive me. And I thank you for your patience and your understanding, along with, of course, the supervisors, the audience over here, and believe you me, I mean, 11 years has taken a toll even on me. I'll be happy to answer, of course, any questions in this regard. So thank you for your time.
Thank you very much, Pawan. Now I will give the word to Frantzeska first and Mervi next for questions and answers and some debate.
Yes. Thank you, Pawan, for this very interesting book and for actually engaging in such a challenging topic and a difficult one, and not only a difficult topic, but also the way you've chosen to deal with the topic has been a difficult one since you've chosen interdisciplinarity. And I think this is a very welcome approach. I think I agree with you. You write it somewhere in the thesis that these issues cannot be answered by law alone. You need to have a broader perspective, and you need to look into, to use different layers of methodology to get answers. I think we will have the opportunity to come back to that issue of the role of the legal research in your thesis, or the lack thereof. So I will focus, most of my questions, or almost all of them, will concern your chapeau, the first part of your thesis. Also, since the articles are co-authored, I think that it is in the chapeau I hear your voice clear and loud. But also this is where I want to find the parameters of the research, the methodological discussion, your research questions, and of course, you know, tying up your research results as they are presented in the articles, bringing them back to your general research aim with the thesis. I have some general comments and where I think there are some weaknesses in the thesis, and after I present these, I will straightforward go to the questions so we can have a discussion. I think it's much better. I feel that in your planning of your research, in your setting up the architecture of your thesis, you don't always provide the reader with a clear specification of the parameters of the research. You use very often terms such as attain, expand, and exploit intellectual property rights, and this is also part of your main research problem as you formulate it in your thesis. But it seems to me that in your thesis there is no clear specification of what these three words actually encompass. What is it that is included under these three words? And as an IP lawyer, I am very curious to hear what expand means really, and we might be able to come back to that. The referencing is sometimes suffering in the chapeau, since you have long texts with no references, you have some general remarks, you write several authors, or there are theories, but there are no references to that. And there is sometimes some issues with the transparency of the research results, I think, since one issue is, of course, the choice of countries you have made. You have decided to compare Estonia, Germany, and Finland, but I couldn't find anywhere a real good description of why these three countries are to be. I understand Estonia, of course, for obvious reasons, but why Germany and Finland would be included. And actually the same goes for the term intellectual property rights, because I have the feeling, and it might be because I'm a patent lover, I have a feeling you use the term intellectual property rights, but you really see the world from a patent perspective. So, and I see it in the way you're writing. You write intellectual property rights in general, but you use a lot of patent law references or patent-related references. Sometimes I couldn't really distinguish between what was the product of your own research and what was already out in the literature. And you have also some, I would say, dogmatic statements that I couldn't really trace back to either the research provided for in the thesis or what is provided for in the literature. These are kind of my general comments. I want now to go forward with some questions, and I start already with the first, something you've written in the first page of the thesis. So you write, there is a discussion on what are the best ways to reward inventors and whether the existing system of IPR can survive in the era of digitalization. This debate falls outside of the topic for this research, and the author works on the assumption that even if details may change, the core idea of a need to reward innovation remains, and the challenge for states is how to do this in an effective manner. Is that your starting point? And if that is your starting point, how has it influenced the way you have looked into your research questions?
Well, I've worked as a lawyer, and of course, IP is very relevant there. But my view about these issues has really been influenced by what I've seen in the university, where I've been associated with for a long time. I also teach IP to science students. And the whole idea here is the outreach aspect. And as part of my research, I also looked into what motivates people. And in the academic context, in many instances, what I've seen here is a sort of an aversion to IPR, as if IPR is non-rewarding by itself. It's a strange situation where, rather than patenting, the emphasis on publishing. And somehow, it's not understandable or comprehensible to me as to why somebody would just be happy with 5,000 euros or 6,000 euros as a salary from a grant that you run across for 2-3 years and then go for the next grant. I mean, why wouldn't anybody want to exploit the IP that is obviously generated in huge volumes within the technology universities, especially the one where I am in? And so this question that came up was about rewarding, and why is it that somehow it doesn't appeal at all? And this has been a debate for a long time in many other countries as well. Everybody wants to make Stanford and everybody wants to make Harvard or whatever, but nobody wants to sort of look into why don't professors want to exploit their IPR? And we have had a lot of issues. Now we have a new person from Tartu University who has joined our university as a vice rector for RDI, and it's the same push. We've been trying to push this whole IPR formula, and there's this whole rejection of it. And then when I looked into some of the articles and I did some research, it turns out that professor-driven research is now only visible in Sweden and not many other countries in the European Union. There have been changes. Finland used to have it, but now it has also gone. The whole idea that maybe the professor should own the IPR and then license it to the university, rather than having a situation like I have even now with my master's level engineering students, whose question is, I mean, where's the money? What's the point of getting a patent when nobody cares in the university infrastructure? So this rewarding aspect, somehow under the viewpoint that money would make things move. Despite all the technological changes, despite whatever happens, we look at the Digital Markets Act, the Digital Services Act, everything going online, everything digital, how copyright moved in, how various other legal aspects moved in, how the transfer of technology block exemption regulation is being amended, changed. There's so much happening in the digital sphere, but people don't see the point of exploiting IPR. I've joked about it. Maybe it's like European Union research funding. It's like, well, pardon this usage, but since I'm here.
But I think EU research funding is promoting, they want you to have an IP policy in your project in order to get the funding. So I think the awareness is there. And it's interesting what you're saying, because I like to see intellectual property rights in layers. First layer is identify the potential of protection. Second layer is look around you. Are there other third parties' intellectual property rights that might be infringed by what I'm doing? Third layer, apply for protection. And then fourth layer, exploiting. So, I mean, and there are a lot of situations where people have intellectual property rights but choose not to exploit them. And I don't necessarily think this is a bad idea, because sometimes you want to have an exclusive right to prevent anyone else from doing the stuff you are interested in. It's not necessarily so that you want to exploit the rights yourself. Okay,
but maybe if I could, you know, what rankled me once was there was this report from our technology transfer office, and they made some revenue from licensing. This was several years ago, and it was 32 euros. I mean, this thing is not sustainable. There's something seriously wrong here if the full licensing outcome of an entire university is ridiculous like this. I mean, we're looking at something that could easily be worth millions of euros or hundreds of thousands of euros. And there has been a push for this. But yes, this was the starting point right in the beginning.
So if we continue with your take on the intellectual property rights system, you write in your second page that the thesis focuses on patents, trademarks, and copyrights. These are typically seen as the most important forms of IPR. And I was wondering, how have you identified, why are these the most important forms of IPRs? You're looking into intellectual property rights protection from the lens of SMEs in your thesis, right? Are these rights the most important one? And how about design rights? Later on in your thesis, you refer to design rights shortly, but these are excluded from your, you know, the architecture of your research. Why is that?
Well, even in the EU IPO in Alicante, I mean, they've always referred to design rights as the Cinderella. They have made some new changes recently. In my professional career, I would have said maybe I've done almost 5,000 trademark applications personally, almost 1,000 patent applications, or that was PCT, so that's not as great as it sounds as. And copyright, of course, quite a bit. Not a single designs law application. And even over here, even if you look at the issue of something different, like utility patents or something, I think what you could see over here is a distinction with what you see in Finland, for example, where Aalto University has this huge, and Turku University have this huge department just dealing with design aspects. I have dealt with design aspects within the Tallinn University of Technology context, and again, it hasn't really gone forward much in this regard. It's also the fact as to why the new design regulation has been drafted. It has been in the works for a long time. It has just come into force now. And it's just something you don't see here.
So you mean important in terms of how much they're used, not important in what role they can play. Is that the case?
Yes. Again, in a utilitarian context, just having a portfolio by itself, would that be sufficient, or something that is exploitable? Right. And, well, at least in these parts, I don't see them.
So I move forward a little bit in your thesis, and in page 23, you write that Estonia is a highly innovative country that has pioneered elements of knowledge-intensive entrepreneurship. And then you write one sentence beyond that. However, at the same time, the level of IPR protection is low. And I was wondering, what do you mean by the fact that IPR protection is low, and how do you actually measure it?
Well, measuring, of course, is an interesting issue, and I've spent a lot of time on the articles on whether we look at productivity in the context of RDI, or whether we look at propensity to apply and acquire IPR. And I think the issue here has been that in Estonia, there's been a lot of pride with certain issues, certain companies, starting with Skype. Skype was seen as the, I've been here for 17 years now, and there's always been the question of what is Estonia's Nokia? And this has, of course, evolved over a period of time. In fintech, there's been a lot that has happened in recent times. There's been a lot of emphasis. There are a lot of startups which have been very broadly advertised and showcased as this is e-Estonia, this is the modern stuff, this is what we like to do. And then, of course, it's something that really, hits all the right buttons. We had people from Azerbaijan 2 months ago, and they were like, wow, we want to know about the e-Estonia story. And then I'm this damp squib talking about...
Does e-Estonia presupposes intellectual property rights protection?
Well, the problem here is there's innovation, and of course, even the innovation surveys would show there is high innovation. But when you look at the numbers, IPR registration is not high. And that leads to what the surveys that I conducted, but also what various other independent publications, articles, reviews, researchers have proven, that somehow you have innovation without IPR.
How about unregistered rights? What would you say about that? Because there is still intellectual property rights. You mentioned copyright in your research, project proposal. These cannot be measured. So, Skype and the like and other companies might have a broad IP portfolio, but that's not something we can find in a registry of a patent office, right?
Certainly. And in fact, even last night, when I was rereading all my articles for the millionth time, this is something that Article 5 goes into in such detail. And this was, of course, in 2016. This whole idea of maybe it's not on paper. It's there, it's unregistered. And then unregistered, of course, we understand them in the context of, for example, copyright. There's no register of copyrights as such. Of course, you can claim it. That's a different issue. Designs can be unregistered and registered. And I have looked into this in great detail in Article 5, then also Article 4. A lot of it has been tempered by, again, very valid criticism by both my supervisors who have been like, Pawan, you're not patent Dutt, you're Pawan Dutt, and get away from this whole patent idea. And I've tried to water it down, unsuccessfully, of course. But yes, there are aspects of whether it's unregistered, and there's a lot of research, even in Estonian context, which I have also cited over here, and the overemphasis on trade secrets, or the idea that technology moves, and maybe the way ahead is to just have changes in the algorithm, or changes in the design output. Who goes for IPR? And I had to spend several pages trying to still say that, look, some of the top IP registrations are still Microsoft and Facebook and Alphabet, Meta and Alphabet, and IPR is important, and registration is a signaling aspect, and you have an IPR portfolio that leads to valuation, and of course that gets me in more trouble with startups when I try to say that it's all hype if it's not followed up or backed up with a portfolio that shows you have done things. You can find financial instruments and VCs or whoever, and that model is coming to an end. Even in Europe now. So yes.
Okay, looking into your research questions, I am wondering, in your first research question, question 1b, you write, why are social system capitals in conjunction with motivation relevant for sustainable RDI laws and policies? Which are these laws and policies? What specific forms of legislation are you thinking of here?
Well, this was, I believe, Article 2, and this is the one that was published in Redford with the University of Lapland being the editors. And in this context, I had looked at not only the TFEU and, of course, the state aid requirements. There are a lot of case laws that were investigated, but there are also these block exemption regulations. Then there is the RDI directive, which very conveniently changed last year, got amended. And so there were about 7 or 8 different legal statutes within the European Union context.
And since you have dealt with directives, did you look into the Estonian, German, and Finnish implementation of the directives?
Well, not really, again, because this is not a legal thesis as such. But yes, some of the issues have come up and have been investigated in the context of state aid and how much funding would be then permissible if it is allowed. And so the numbers were investigated into. And this sort of helped me to really look at how this works. But maybe I could add over here, although I'm sorry I'm taking your time.
No.
For a long time, I had this question, this doubt. What am I doing? Am I doing it right? Am I correct? And Article 2 was the turning point. I hit a wall. University of Lapland, and they really squeezed it out of me. And the review process was out of the world. And that's when I realized that this is not just something straightforward. Some of the people who reviewed me have been cited by me because they are raising questions which wouldn't make sense. And this was really the turning point for me.
I think you're dealing with very difficult questions, and actually one of my objections is that I see several theses in your research questions as they're formulated. You mentioned state aid. I will not go into detail discussing that, but you're making some points in some parts of your thesis, both in the beginning and in the chapeau, in the beginning and in the end, in your final conclusions, that would really require a lot of hardcore legal dogmatics work to draw conclusions about. So state aid in itself, in this field that you're looking in, is a gray zone, a very difficult zone, even for state aid experts. So, and we will not discuss more about that, I think, but you're changing the order of my discussion, but I'm a bit provoked now, because you said several times, this is not legal research, this is not a legal thesis, and this is an interdisciplinary thesis, right? And I'm really intrigued by the issue of interdisciplinarity. In my view, interdisciplinarity is bringing together different scientific fields to deal with a problem that is interdisciplinary per se, right? And you have such a problem here. But I still think that part of the answers to your interdisciplinary problems are to be found in law. Then this is not only a legal thesis, I would say. You take the results of your legal research and then you apply your other methodologies and you bring a much more interesting result. Because the law would how do you say, it gives you limited answers, right? The law tells you what you're allowed and not allowed to do. It doesn't really tell you how to achieve the objectives that you're dealing here with in your thesis. But that means that you have to be able to show that what is pertinent to legal research is done in a correct way. And sometimes when I read your methodological discussion, I feel that you are avoiding the classical legal research requirements, right? And I see that also in the way you deal with your sources. And this, in my world, is one weakness, because you are a lawyer, you have a very impressive CV, and I think doing the classical, boring legal research work would be quite easy for you, to be honest. So there we are in kind of a disagreement as to the character of the thesis. I agree it's not a legal thesis, but there are legal issues you're dealing with that you actually, the answer to these legal issues you then take as a starting point for your further discussion. So if these are flawed, then your end results, the interdisciplinary results, are flawed as well. And you mentioned in one of your in the limitation slide, you mentioned that, well, I've chosen peer-reviewed journals, and the question is, were they the external reviewers, were they able to, guarantee the quality of the work. And I've seen that the journals are law journals, right? At least the majority of them. So why choose law journals if this is not a piece of legal research?
Well, I think what sort of sums up my approach has been, it's this English phrase, running with the fox and hunting with the hounds. And it's been a journey in the sense that a pure IP or a pure legal outcome was off-putting for a lot of the people within the system, because the question was, is this your PhD, doctoral, Juris viewpoint? And then I've seen how law tends to sort of, well, okay, that's one aspect. That's something about the off-putting part. But another thing that I've realized as a lecturer for first-year law students in the bachelor course is when you take something simple, even simpler, not Grundnorm or that simple, cloaked with legalese, and then you throw it in the class and you see how everybody jumps on it. With law journals also. I had the same issue even with the University of Lapland people, the Redford. It's not highly ranked in the context of 1.1s or whatever we have in Estonia. This was 1.2. But this whole question that, okay, we don't look at law, we look at things around law. So you're a lawyer and try to talk about this issue without bringing in the law. And no matter how I try to keep that genie bottled up, it still peeks out, and I have to struggle to put it back in. And of course, it's visible here. There are 3 more articles coming out next month. And again, that brings us to the fact that this is just, as the years passed, I just didn't stop researching, and it's just gone crazy. It's become this super big tree that needs to be pruned somehow. Yeah. But yes, it has sort of influenced my understanding that the law doesn't answer all the problems, especially when it comes to drafting policies.
No. Of course not, and I totally agree, but I still think in the parts of the thesis where you seek an answer in the law, you have to keep legal methodology intact
Certainly.
And correct. Otherwise, you allow for leakages in the rigidity of your research results. And I'm also a bit curious because we talked about that just right now. You're a legal scholar, you were a lawyer, and in several parts of the thesis you refer to your personal experience. That you have chosen literature on the basis of your personal experience, and I see that now. It's so interesting talking to you because you have all these personal, practical experiences as well. And this is an asset, but it can also be a weakness in a research setting, right? So what is your method, what is your toolbox for guaranteeing that your personal experiences are not influencing the flow of your research and that you can still keep the scientific character?
Well, of course, this has been a very tricky situation. Maybe one way to deal with it has been as approaching different journals. So this is not a monograph, my word, how I see the world and things like that, but rather it's been broken down into 6 different articles published in different journals, law and business and other journals. And so they have sort of helped to keep things somehow in a non-legal sense. But this is something also that came up when I had gone to Dresden, Technical University Dresden, and I'd given a guest lecture on copyright and film licensing. And the question that came up was, how do you avoid going to law courts?
But why do you have to avoid going into... It seems like the fact that you are a lawyer is kind of a weakness, and I don't agree with you. My question was not, how do you keep outside law from your work? My question was, personal experiences or practical experience that you might have, it's not verifiable in a scientific way. You have to see to that you can verify that. Even if you're not in law, even if you're in another field. Okay, here we have experts in other fields, but since I am interested in interdisciplinary research, I know that personal experiences are a weakness that you have to deal with methodologically, so irrespective of law or not law. I will continue because I don't really know how much time I have. You refer to the unitary patent system and you describe it very briefly. And I think what's revolutionary in the unitary patent system that is relevant for your research is not so much the grant of the patent, it's much more the enforcement of the patent, because we have a completely different setting now. And I was surprised to see that you do not refer to the Unitary Patent Court and you don't discuss the effects that the Unitary Patent Court will have when it comes to what you are interested in, namely the exploitation of intellectual property rights. And to be honest, when it comes to research question 3A, I wasn't able to find an answer in your question, somewhere in your articles. And I think in the table you have provided with the questions and the publications, I don't think you indicate where this sub-question is answered.
Maybe if I could.
Yeah.
Well, of course, the Unitary Patent Court system has just come into force from mid of last year, and we're looking at majority of the judges who are now basically from Germany. The three courts that have been set up in Milan, Paris, and of course Munich. Well, we're going back to basically 2023. I think none of this was really out there when even the review process started. That was 2023 beginning.
The structure of the court and the way the court would function was already out there.
The system, yes.
We did not have an experience, but there were a lot of academic publications concerning the effect the Unitary Patent Court will have in the exploitation of patent rights in the European Union. So,
yes.
And this brings me to my next kind of concern, not concern, but maybe question, linking back to what I said in the beginning, intellectual property rights versus patents. Because if you are looking into the unitary patent system, and you mentioned in the beginning of your thesis, you mentioned that patents, trademarks, and copyright are important IPRs that you will focus on in your thesis. Why don't you mention the EU trademark?
Or the Madrid system.
That's kind of, I think deep inside you wanted to write about patents, and somehow you expanded it, because this is my impression by reading your research. And I don't think this is necessarily wrong. I think patents are a bit special intellectual assets in the whole system. Okay, I mentioned in the beginning that I was curious to hear why Estonia would be compared to Finland and Germany. And I couldn't really find a good answer in the thesis, but maybe you have a good answer now.
Well, I believe Article 4 starts off with Finland and talks a lot about Finland. And Finland holds a special place in Estonia. Well, I'm married to an Estonian. Every Christmas and New Year has been with Estonian family now. There's this whole idea that somehow Finland got ahead. Finland and Estonia were together. Mm-hmm. Everything was going good in the 1930s. And 1940 happened, and it ruined things and put Estonia back. And there's always been this, maybe I'm being a bit flippant about this, but Estonians think about Finland, Finns think about Sweden, Swedes think about Norway. In a weird way.
Norway? No.
Well, maybe not Norway in that sense, but at least from Estonia to Finland and Finland to Sweden is a very logical way of looking at things. That's of course number one. And it has a real impact. We have had dealings with the University of Helsinki, Aalto, Turku. We have had Finnish professors coming in. There's always been this bittersweet relationship thing. Look at Finland. How did they do it? They did it because the Soviet Union messed us up somehow. There's always been this thing in the background. And a lot of the policies you see are, how would the Finns have done it? And of course, this sort of changed over a period of time. But Finland is, from an Estonian viewpoint, a very logical next step. I mean, Estonians wouldn't compare themselves with Latvians or Lithuanians in that sense. There's always been this battle to get away from the Baltic stamp into the Nordic stamp, and this has been, well, this is again maybe a personal bias. Maybe my family members from Estonia are the wrong sort.
But are there any scientific reasons for comparing Finland?
A lot. In fact, the whole article that is on Estonia and Finland goes into...
I think you described the comparison because I read the article very carefully. I was very interested because you mentioned something that I find quite intriguing and that I would welcome reading more about, namely the Soviet past and how that might, if there is any heritage to keep away from or to take into consideration. So I see the comparison is there, but not any discussion on why these two countries are to be compared, apart from what you're saying now, that the Estonians want to be closer to Finland. And the same goes for Germany. You compare the two countries, but I couldn't find anywhere, either in the articles or in the chapeau of the thesis, a discussion as to why Germany. I mean, Germany is obviously an interesting country, but when you're comparing countries, you have to have some kind of a scientific reason for doing that, either the similarities or the differences that make a comparison interesting and that can help you answer your research questions, because in the end, the reason you have the comparison is to help you answer the research questions. How am I time-wise?
You have been speaking more than 30 minutes.
Oh my God, okay, so I should...
It's okay, I mean, it's an interesting discussion.
Okay,
so
that's good.
because you have discussed all my points already.
Oh! And since we were talking about the comparison, you write in part 2 in methodology, I think it is page 53, you write, what right kind of new insights and empirical patterns, that this comparison will give you the right kind of new insights and empirical patterns. And I'm wondering whether you could sum up very briefly, what are the new insights and empirical patterns you got from comparing Estonia to Finland and to Germany, respectively?
Well, on the one hand, of course, the size difference does make them seem very odd as compared to fellows, but the legal aspects, as far as Estonia is concerned, especially the IP background, has sort of really been very influenced even by the German aspects. The interesting thing was that what Germany, of course, much earlier, and Finland, especially in the 80s, experienced is what Estonia is trying to get as an experience now. And then, of course, the legal background is still the same. And the directives are applied. There is the regulations, of course, to come into force. So when we look at it, okay, if we try to separate the fact that there is this huge giant of Germany compared to a much smaller Estonia, some of the legal reasoning is in fact, not some, but most of it is quite similar. And I think what the cultural patterns was a reference more to the social systems theory, where again we are looking at cultural, economic, social, and strategic aspects. And what came out was the emphasis on universities. And this is something that is quite an issue, because again, my children study in Estonia. Everybody's very proud of the PISA ranking system. But then comes the next question. So when are the new patent inventors coming out? When is the next Nobel Prize winner coming out? But you see, it's not logical in that sense. And even this model talks about these 4 capitals which have to be balanced and adequately developed. And of course, this has been something that came out from the comparison with Estonia with Germany and with Finland, that the networking aspect within, and that's the socialization part, and the whole culture of IPR, and how that can be developed, not purely from just drafting policies or laws, but rather from inculcating this at very initial levels and at very intricate levels, not just a little speech that IPR is important or RDI is important, but how to bring it completely into the system, into the architecture. So that's been more of the outcome.
Quite late in your thesis, and I think it's page 69, 72, where you discuss the answers to research question 1, you refer to employee-employer relation, which you don't really discuss earlier. How important is this perspective for your research results?
Well, it was about motivation, so it sort of came back to the very beginning aspect, and how as an employer can you motivate an employee, and even in the revised framework, there's a whole emphasis on motivation, and whether IPR should be in-house or outsourced. So that was one aspect. Or secondly, can motivation be culturally ingrained within a SME?
But if you're looking at how the state can promote IPR, getting IPRs and expanding and exploiting, why do you care about the employer-employee relation?
Well, that's the state part. The state can do so much. But then the question that comes up is, what about within the organization? And that's, of course, where the 4S theory comes in. The state gives you the money and says, OK, do it. And still you can't do it. And that would be because the employee doesn't feel motivated enough or rewarded enough. And of course, the law part comes in here. Who should own the IPR that the employee creates?
See, the law comes up everywhere. We are in an agreement. No, I'm just kidding. OK, final comment or final question and one more comment, and then I am. Otherwise, you have to indicate that I'm talking too much. OK, so another thing that surprised me when I read the thesis is that educational policy, education seems to be very important. You mentioned it several parts of in your thesis and in the articles, but yet there is no research question related to that. And why is that?
Well,
if it is so important, why isn't it in your research setting?
Actually, well, of course, education as a variable has popped up a lot right from Article 5 and onwards in the econometric analysis, etc. But education in this context comes within cultural capital. And, well, there's a whole big definition, and of course, this Appendix 1, Table 5, which talks about culture. And it's about RDI culture or research culture or any other forms of culture. And education plays a huge role in that. And when you talk about changing mindsets, changing cultural patterns, from a social viewpoint, strategic viewpoint, economic viewpoint, but it still comes down to education being lumped in the cultural context. And again, that's where the very valid criticism comes up, which is, what the hell am I doing? This is all over the place. And of course, there are so many things that are being explored over here. Well, 6 articles for a PhD defense by itself.
It's quite a lot.
I think the trick has been in putting them together and still making sense. While it makes sense in the head, well, of course, all the patterns, all the drawings, all the diagrams, everything, it all makes sense here. But conveying it is, of course, the issue.
I said I will only have one more, but it brings me to another thing that I think is interesting. You discuss the differences between industrial sectors at some point in your thesis, also quite late in your chapeau, I think it's page 83. And I'm wondering, do you think you have a subject where you're able to generalize so much in your conclusions? It seems to me from the empirical data you're presenting that some issues are extremely industry specific. And do you risk in, do you increase the vulnerability of your conclusions by having this broad perspective? Would it have been better to just choose an industry to look from, to use as a lens for your research questions?
I think that's why the whole utility of the idea of patents has come up, and triadic patents. And then if you look at the technologies that have been focused upon, the top 3 or the top 5, and then the ranking system and how it works. And again, that's where the utility comes in. And I believe in Article 5, there's been a lot of debate about this as well. It comes back to the same thing. How do you measure RDI output? And this is not a new debate. This has been going on since forever. The NASA space shuttle goes up into space. So what? What's the outcome? I mean, do we just look at the inputs as PhD, tuition fees for the scientists, or do we look at the context of how Teflon was an outcome? And this has been a huge issue. This has been dealt with in the context of productivity vis-a-vis propensity to apply and seek IPR. And that's where patents comes in very handily, because you can't get a patent for just about everything. Of course, a funny name or a catchy name can be a trademark, a piece of performance. Even something like this could be copyrighted. But for a patent, there's already a criteria. And that sort of, in my mind, narrows it down to not just anything that you can apply and get, but rather something more specific, something more technological. And when that debate starts, then it doesn't matter whether it is a certain sector, but rather it is about the broader picture, whether, even the new RDIE policy, so you throw €1 million at an institution or an organization and say, okay, play with it. How do you guarantee that they don't spend it on a month in Bangkok or something?
Sounds nice, a month in Bangkok. So, Pawan, last comment, really the last one. You wrote 6 articles from 2014, or they were published 2014 and 2021. It is still kind of a broad time range for such a subject where a lot of things happen. Do you think you have had to revisit some of your conclusions when finalizing your thesis? Or were the early publications still valid?
Well, on the one hand, you could look at just these 10 years and say that's a long period of time. But actually, I've been practicing since 1998. And I always come back to the same thing. The more things change, the more they remain the same. It's the same story, new wine, old bottle. Some things never change. Just they never do. Maybe my 25 plus years of experience has shown that nothing really changed drastically. There have been incremental changes, 2 steps forward, 1 step backward. But in this 10-year period, I wouldn't say that, oh my God, this is a different world. 2013 was so much nicer or different. It hasn't.
Yes. And Pawan, just a closing remark. You mentioned several times it took you 10 years to finish, 11? Yeah. And I can tell you it took as much time for me. I was doing different things at the same time as I was writing my doctoral thesis. And I like to think of a Greek poet, Kavafis. He wrote a poem called On the Way to Ithaca. And he says, what is important is not the destination, it is the way there. So I'm sure you acquired a lot of knowledge, a lot of experience in your trip, and I'm very happy to be here today when you're finally in your harbor in Ithaca. Thank you so much for this very interesting discussion.
Thank you.
Thank you so much, Frantzeska, for your very thorough address to Pawan. Mervi, do you want to take over from here?
Yes, thank you. Thank you for this presentation and also this discussion. But I must admit that I'm in a very difficult position now because almost all my questions have already discussed or answered. But maybe I can have some comments from the other angle also. So first of all, I think it is, of course, a strength to have 6 publications, 6 articles. But on the other hand, it is also very challenging to get all these 6 articles under one roof. And I'm still a little bit confused how these two aims and research questions and articles are connected with each other. We can see from the figure 2, it was how you connected these articles with research questions, and on the other hand with the aims, but how they are all related to each other. It is, I must admit, it is still a little bit confusing for me. But I also appreciate that you did this work because it is interdisciplinary, and of course in entrepreneurship we have, and economics we have one tradition for research, and in law you have different approaches. So I think it is my problem. You also all discussed about this research question. I had also questions about this 1B research question, but I got these answers. And you discussed also the comparison between Estonia, Germany, and Finland. And you discussed this law or legal system context. But what can you say about these economics and entrepreneurships? Are they similar, or how you will comment this?
Well, I have been involved with Germany in other contexts as well, with cooperation with other German universities. Next month I go to Berlinale, the film festival, and I've been doing that for several years. And my understanding, of course, a lot of German colleagues in Tallinn, a lot of Germans in Tallinn. What I have seen here is, of course, you see, it's very easy to say, come on, Germany is super huge, and how can you just compare Germany with Estonia? But on the other hand, coming back again to this, maybe this legal training of, well, maybe if you peel away the various peels that you know, it's like an onion. In the down below, there's not a very big difference in certain aspects of Estonia and Germany, and well, not in the macro or even the microeconomic aspect, but more rather in what are the boundaries within which both have to perform. For example, at one point, no matter what the Germans do, there is still the same restriction that even Estonia would face. And of course, it's easy to say, well, Germany has a lot more money and a lot more history, and look at the university system, look at the networks, look at all these institutes that have been outlined. I believe in Article 3, the whole support infrastructure, and look at what the Germans are doing. And then, of course, even if you look at so many Estonian companies that then eventually migrate to Germany because of better subsidies or better policies. But the same questions come up, and that would be starting with something which we don't admit, but which is here in Estonia, the elite school system. Yeah, it's like the more you scratch, the more you find there's this German influence in a way that comes up. Of course, there are restraints. There are restraints, especially in the context of money. High technology aspects. Even in Saxony, Dresden is now known as the capital of driverless cars. So it's a contrast to Munich and the automobile industry there. So you can see how so many things are being done at the same time. I mean, it's mind-boggling. Vis-a-vis Finland, which just focused on 2 or 3 things. Yeah, in the 1980s and 1990s, as the patent analysis shows, ICT. Stick to that, maybe a bit of chemistry, maybe a bit of other things. Okay, there was shipbuilding, there was timber, whatever. We don't focus on that. So you see the patents in all the other industries came down, but ICT was the main focus. And Nokia is not there, but then it sort of spawned so much more. But that was also a complaint about Finland, that maybe it's not diverse enough in the context of technological focus point from the government's viewpoint, the public support system viewpoint. But what Estonia looks in Finland is Finland, which is on steroids, which has maybe 10 times, 20 times more better possibilities for historical or whatever reasons. And then logically, if you look at what would Finland be considering, I mean, besides Sweden, Finland would obviously be looking at Germany. And this is, I think, again, something that came from one of my travels during projects. Moldovians look up to Romanians. Romanians look up to Hungarians. Yeah? Hungarians look up to Austrians. Is that a bad thing? No. I mean, would it be better if Estonians look up to Russia or CIS? Well, that choice was made a long time ago. So this progression, I wouldn't say France. I wouldn't say Italy, because it doesn't seem natural. What seems natural is my wife's grandmother saying that in 1944, when the Germans were there, they came politely and they paid for the pig. But when the Soviets came, they just took the cow away. And you see, I mean, this is crazy stuff, but these are, again, biases, yes, but there are negatives, but Germany is a role model. And well, my belief has also been, if you aim for Vimsi, okay, you'll probably reach Lasnamäe. But if you aim for the moon, you'll probably reach Stockholm or somewhere. So yes, that has been the key aspect of why Germany has come up. And there are a lot of lessons to be learned from here in simplistic terms, not the big terms. If you forget the big terms, just look at the simple terms. Germany has a lot to explain in the very basic context of collaborations between universities and the state model of incremental innovation. They don't want to be Las Vegas or Stanford and change the world. They just want to do simple things more and more efficiently every year. And that reminds me of the Alaskan gold rush. And somebody who said, if you want to become rich, don't search for gold. Sell the spades and the pickaxes. And all these people who are looking for gold will buy the stationery from you. And that's what Germany has been doing, incremental. Has it been successful? Well, no, of course not now, because Russian gas is gone, and so everything is now super expensive. So, of course, cycle comes back. But there's still a lot that Estonia not only absorbs, but also would like to absorb in a positive sense from Germany. And that's what at least that article has showcased, besides the other research models.
Okay, thank you. I also wanted to add that you mentioned that more than 90% of Estonian companies are micro enterprises, but in Germany we have very big companies. Is it also a problem or what?
Well, the research shows that a lot of changes were done, of course, in the Federal Republic of Germany in the 1980s. And there was a lot of focus not only on the big companies, of course, the big ones are always there, but also on the smaller companies. And a lot of funds were provided, a lot of state support was provided. And again, of course, this was Federal Republic of Germany, and this was before the 1990s. And subsequent to the reunification, there has been a lot of focus on bringing up Eastern Germany to the same standards. And one easy aspect is, which I've also referred to in my articles, you set up a cluster of industries, what can go wrong? I mean, and Dresden is an example of that, Saxony is an example of that. But there has been a lot of emphasis even at the micro level, and that's what the research has shown. So now, is Estonia in the same situation as maybe Germany was in the 1980s, in the context of shifting the focus from bigger industries, which, okay, we don't have here, rather to individuals and companies, and then the startups and the unicorns, and then push it forward, push it up, and maybe hope that it builds the infrastructure like how Finland did with Nokia in the 1990s. So a lot of thought goes into these things, and the research development and innovation this study that has come out, and it also talks a lot about various issues, and these have also been seen as not a positive, but rather a negative, but they have been published, and also I've quoted a lot of articles from Professor Tonis Metz and others who have also looked into this issue. But the question here is, you see, a unicorn can only be financed once in 2 or 3 years and grown into something super big. And then it's a hit and miss affair. But very often, there are a lot of smaller companies that can be set up and startups, and especially in the university that I am in, and even in Tartu, I believe, there's a lot of push on helping students to come up with the next big idea. Nobody is going to put in 100 million into them and turn them into Bolt or Pipe Drive or anything like that, or Vice, but rather from a lower level, and bit higher, and to see how it goes. So micro and small enterprises are fragile, and they need inputs. But at the same time, you just throw money at them. How does that solve anything? Rather, why not make them indulge in RDI and come up with something that is verifiable, and that would be an IP portfolio. And that's where the emphasis has been in the articles.
Mm-hmm. Okay, very good. You already moved to universities, and I have also questions about professors and their knowledge and patents. For a professor career, it's very important to have articles published in high-ranked journals. But if we publish our inventions, we can't have patents. What is your recommendation, how to solve this dilemma?
Well, a push happened already in the time of Avikso, and in the Estonian context, well, he was a bit rough, but the matrix was changed, and it's sort of now in Taltech would be that 10 articles are equivalent to 1 patent. But not a patent in Estonia, an international patent, which would then be in the same category as a 1.1 or even higher than that. And I believe the issue here is my wife is a school teacher. They're going on strike soon. At different levels, there have been questions about what can be done to improve financial situation and things. But I had this one case where one of the professors came to ask me for advice. He said a doctoral student who was being jointly supervised by an American and an Estonian professor is now nearing the defense and everything is done. And the American supervisor is saying, you know what, let's rush this through, or let's at least apply for the patent, because that's more important than this PhD. And the Estonian professor was like, but this is a PhD, and it has more importance and relevance than a patent. But the American supervisor was like, come on, this is big money, and why are we delaying this? And sign an NDA, do whatever, push through the defense process, but apply for the patent as fast as possible. And I would like to believe, and I have also been talking about this in my classes for STEM students, that patenting is much, much more important in the long run. But of course, that would also mean that you have professor-driven groups, and then these form clusters, and then these form institutions, and then you have students who don't just go to work in other companies, but rather become entrepreneurial and then try to build up a business. And well, in the context of the Taltech University, that would of course be engineering, which would then be a patent primarily, besides other forms of IPR. So I would still say that patents could do things, because I really believe that in Taltech, we are sitting on top of a gold mine. There's so much innovation that takes place. We have professors from all over the world, people who do world-class research. But if there's no money coming out of this, then there's something wrong here. And I believe it's time to rectify this, because every year we have the same debate. how will salaries increase, how much more will the government give, and Kaya Kallas and whoever before her has always promised things. But money doesn't just come from nowhere. And of course, the question here is, if an academic could be an entrepreneur, then why would they be in academia? And so now, maybe you can be an academic and you can be an entrepreneur. And we have done a lot of visits and researches on Stanford and Silicon Valley and all those fancy things. Mectory was one example of how things were planned. But this push has to continue. It can't just be like, okay, forget it, doesn't work out. This is a non-stop battle. So patents, in a nutshell, IPR, generation and exploitation, I believe is very important.
Mm-hmm. Yes, if we have a lot of patents in the university, what about commercialization? How do you evaluate the ability to commercialize these patents in the context, I don't know, TalTech or University of Tartu?
Well, I've been there since 2011, and it's been a disaster. Every year we have a new TTO. Sometimes they bring in somebody from the UK. There was this very flamboyant Estonian with an American accent they brought in. They bring in everybody, and everybody talks, and 6 months later, everybody runs away because it hasn't really worked out. And the ones I know who have stayed long enough, it didn't go well. I mean, Mectory has been a prime example of that. But again, now we have Professor Erkipura. And there are a lot of high hopes from that aspect. Again, commercialization. And that's something that he's been talking about for the last 1 year now. And he was, of course, before this involved in Tartu, built that amazing innovation center and in the infrastructure. But you see, this is the same like how it's been in Saudi Arabia and the UAE, 1980s, 1990s. It's easy to build a house and call it an international school or whatever, but in the end, it's the human capital that plays a role in the teaching. And commercialization has not really worked out very well. But there have been sporadic pushes. Every year, they try to do this, every year, and I believe in Tartu University, they have been quite successful lately in this regard. We're not talking about multi-millions yet, but it's happening. And this is something that I've seen progress over a period of time. In academia, especially in TalTech, now professors don't count on Estonian state money or EdTag or whatever. They just talk about the European Union funding. It's a huge pot, more possibilities there. Projects now don't go for less than €1 million. I've been involved in some of these. And the more we do this, basically the state is pushing away from the whole idea of education being a state problem or a state burden, and rather saying that, why don't you people earn money? And that's what TTOs have been pushing for, but you don't see that happening yet. But in the German example, I've seen in Dresden, for example, TU Dresden, they have been pushing for this a lot more. And collaborations are the key here, of course. Sorry, I got over-passionate about this.
Okay, thank you. And I want to move to this methodology section now. And I had this quite similar concern about this analyzing the data. I can see that you are certainly very good expert in your field. And in this case, there's always a risk that qualitative data will be interpreted similarly to one's opinions. So how did you ensure the objective analyze, for example, these interviews?
Well, something going back to my philosophy in this regard has been that anybody can count. So if you have windows in a house, anybody can count and say there are 6 of them. So that's the easy part. But why are most of the windows in an Estonian house south or west facing, or compared to maybe a house in India, which would have windows all across? And that's where other factors come in. So that would be, as I looked into, and that's why I like this particular theory. You look at the cultural, economic, social, and strategic aspects. And so as far as the interviews were concerned, these came at a much later stage. Basically, what was already formulated before this was the theoretical approach and the look at how these different key factors, the 19 that I had identified through comparative analysis. And this was then transposed into those 4 capitals. And of course, then came the question of testing this empirically. Well, of course, you couldn't call this, the sample size is too small to justify calling it a full-fledged investigation. But then that's how the research questions, or rather the interview questions were drafted. So, I mean, it's semi-structured, not because I just went and said, okay, tell me what can Estonia do to change things, but rather the questionnaire was more about what sort of IP disputes have you had, just to look at whether there is an IP culture, what sort of employees do you have who deal specifically with R&D? Again, that's a cultural issue. Have you had exposure to foreign IP or foreign IP disputes? And again, this would then reveal a strategic aspect, whether the company has plans for a market outside Estonia or outside Europe. So this was, of course, a challenge. And so the qualitative analysis was built around these key attributes that were identified and then sought to be tested. So a lot of the qualitative analysis was then, okay, so these are the things that we have to find out or test and how to go about doing them. And that's how the designing took place. All the literature revolved around that part. Similarly, the other articles, the legal aspect, because at the pre-defense, much earlier than this present one, the question was, okay, what is the legal part? And I thought, you know what, instead of just writing 2 pages on it, I will publish an article on it and do it the hard way. And so, of course, bulldozing through just with sheer numbers of articles. And so, again, a lot of these issues, well, they do seem logical to me in my mind, but they haven't happened in a 3-year or 4-year fixed period as such, but rather in a more long, winding way. But yes, I mean, the structures of the interview questions, everything is interrelated with some of the theoretical aspects. That's why the theory has, I think almost overtaken everything else. It's like almost 50% of my research work. Everything is from the theory point of view.
Mm-hmm. Okay, thank you. And that is all from my side. Thank you for the discussion.
Thank you.
Thank you, Mervi, from your side. So maybe final question from me before we move to the questions that people in the audience might have or online as well, and before the supervisors get the word. So knowing what you know now, understanding the research and that very little things change over a long period of time, maybe sometimes. How would you have designed your research differently if you started some years later?
Well, I don't want to come across as somebody who's stubborn or pig-headed or something, but this sort of a topic, I still struggle to think how it could be done differently. I mean, of course, everybody has their own views about this, of course, and I can't say this is the only perfect way, the only perfect route. But it changed me a lot, the whole journey, and of course also how it plays a role with my work, not only in academia, but also in business. And I think the key part here is still identifying the theory. And I've come across more theories over a period of time, and I still feel that this theoretical approach itself would be the only logical one. And the older I get, the more I begin to feel that this theory, it fits all the things, it ticks all the boxes. And the validation that I got from University of Lapland because of that very difficult review has sort of crystallized my viewpoint that this theory and what I'm on, it may not make sense to anybody else, but it made sense to me. I mean, I wouldn't delete any of those parts at all. Coming to comparative analysis, well, it would still have to be rooted in the European Union. I mean, I could say, okay, look at size-wise, okay, we could look at things, we could look at maybe Israel, maybe we could look at other high-tech countries or whatever, but then that would go out of my boundaries, which are that there are the same legal issues that would still come up if you're in the European Union. So you can't go outside the EU, because that would then completely, radically change the whole viewpoint. Then that would be purely sociological, nothing legal in that context. There's something that binds Estonia, Germany, Finland, and all these EU countries together, and that is the European Union legal framework, even in a loose sense. And so, yeah, I don't think I could do this any other way. I mean, I could, but it wouldn't give me the same satisfaction in a utilitarian sense, because I use these same methods even for my teaching and outlook in life. So, sorry, I wouldn't change it.
Okay. Thank you very much. So, do we have any questions from the floor, from YouTube? Yes, please, Ingrid.
So thank you, Pawan. Really, it's delightful to be here. My name is Ingrid Karinja-Bersinya. I'm here for a nice visit from Stockholm University, and I'm really grateful to be here. So Pawan, I'm a lawyer like you, but I'm writing a thesis in the law. If you could wave a magic wand to change the law, what would you change?
Well, I think the problem that often comes up here is, as lawyers, we work within certain boundaries, and we could try to say that maybe the law should be changed, and that would improve everything. But the reality is that the law doesn't change so easily. It's not in our hands. And if it's not in our hands, then the next issue that comes up is, how do you adapt to the legal situation? And, well, then come the three basics that I shouldn't talk about, but since we are here, and well, rule number one for a lawyer is learn to bend the law without breaking the law. Rule number two, don't get caught. Rule number three, if somebody has to go to prison, make sure it's the client and not you. And now, if you go by this philosophy, for example, you can't change the law, right? But the client doesn't come to us and say, okay, what's the law? And I read out the book, and he will be like, even I could do that. But rather, I think the issue that comes up is, how do we adapt to the legal situation? And then we all have seen that in our life. So maybe the answer doesn't exist in hoping that change will come from outside, but rather, how do we make the changes in an incremental way, not too radical, to overcome certain things. And then the block exemption regulations, for example, are a typical example of this. The law in the European Union regarding IP and competition law, going back to Constant and Grundig from the 1950s, was very rigid. The law changed because the European Commission realized that the US and Japan are moving ahead. So maybe at a lawyer's level, maybe as a lawyer, we can't change things. I think the question is more about, how do we adapt and modify, and and that's also what Parsons talks about, or the social systems theory is about, which is you adapt, you adopt to it, and you make the best of what you get, and the gray zone is the fun part, and that's where the legal acumen comes in. I've been involved in some of these litigations, which have been disasters later on, but that's 5 years later. I've done my billing, I've done the stuff. It's water down the drain, down the bridge. But yes, maybe we can't change everything, and we just take it to the next logical level, which is, okay, what can we do to modify and temper the various issues? Yeah, thank you.
All right, so thank you for that. And maybe now the word for the supervisors. Have you decided who wants to start?
Thank you. I am really happy that Pawan has now managed to get to this final phase to defend the dissertation. And it has been really a very long journey. And today morning I took a look in my computer to the exchange of emails, and I discovered first emails about research proposal from the year 2013. And no, it's quite logical. But what I would say about this journey, I would say that in addition to studying Germany and studying Finland, comparing least to Estonia, you have also educated people in Egypt and Palestine and Jordan. At least I had some email from you from Jordan. So I think you have a really very broad view what are the trends in defending your rights on intellectual property and generally applying intellectual property in corporate strategy and even in a strategy of a small startup. And I was very happy that you also shared your knowledge in a very inspirational way with EBS students when we had this joint program on export development together with Tartu University and Tallinn. And what is most important, I hope that when you now defend successfully your dissertation, I hope you have a good chance to become a really active consultant for Estonian enterprises which are interested to enter new markets, because we can't do anymore it relying on cheap subcontracting. We have to develop more innovative products. And I am also a member of Estonian Business Angel community, and many years they just were speaking, startups, let's run fast. But now we are speaking more about deep tech. And if you want to build up your development strategy on creating deep tech, you have to start thinking about patents just from the beginning. And I would say, at least focus on understanding what in Germany has been done, what in Finland has been done. It's actually very relevant. You made a very emotional explanation. But I would add that we have very high degree of economic integration with Finland. And what about Germany? Our business law, not only about intellectual property, but generally our business law has been shaped by German knowledge. So I think that is a good explanation why we have to understand these countries and how they deal with supporting companies and small startups in using intellectual property in the strategy. So my best wishes to you also as a future consultant, and I hope someday you can also influence even more Estonian politics.
Thank you very much.
Thank you. Yes, much has been said already about the topic and about the challenges, but still I do want to say some words, because we have been working together for a very long time. I supervised your master thesis in the sort of beginning of times, and I defended my PhD 25 years ago, and it was also on a topic that combined, in our case, technology and law, not so much business, but also, and then the whole idea of interdisciplinarity was actually hardly known. I mean, it was not even talked about. Now it's very much talked about and much less practiced, actually, as we all know who try to do it. I think what is very interesting in your thesis is this, how you show the role of law in society. It's not really law, but it's really what does law do and how does it interact with other aspects. And this is very interesting. It's super interesting, but it is very tricky, as was well reflected by Frantzeska and Mervi as well. But another added complexity, which I know well, having worked with you also on some of the articles, is actually the very practical thing that we all talk about it, but we don't do it. So it's very difficult to get interdisciplinary research published, actually. It's really few journals that are really open to accepting that things may look a little bit different than what they're used to. So this has been very interesting. I mean, it's been a long journey. It's been tough work for you, but it's been very interesting to be part of it, to also see how the understanding is growing about this, that we use business, technology, law to kind of create a great sort of combined body of knowledge, let's put it that way. So yes, interesting, and it's so fascinating always to listen to you, because as Tiit also said, you tend to present these nice, more personal viewpoints, but this is not a criticism at all. It's just added to the passion that I think everybody could feel, that I also know very well, and I've sometimes tried to challenge you on that is it really so important with IPR, mainly to be a kind of devil's advocate. And then after a while, I give up because you so eloquently defend it. So yes, I just also want to say I've really enjoyed this discussion, and maybe just reflect as well. I think we would all be guilty of what Frantzeska very correctly pointed out, that we don't explain why we compare with Finland and Germany, because for Estonians this is kind of natural, and maybe for lawyers even more than others, because the German influence on our law, and Finland is kind of Finland. So, but that doesn't mean that we shouldn't explain that, because that's, but still, anyway, so that's just it. Thanking everybody for really interesting discussions.
Thank you.
Okay, it seems to me that we have come to the end of this session for now. So we will break for voting. I will ask everybody else to leave the room. And thank you very much, Pawan. Yeah, we will invite you back in a few minutes. Yeah.
My father passed away last year. I know he would have been very proud of this. Yesterday, I came to know that another very dear colleague passed away, and I guess maybe I'm at that age where these sort of things start coming up, and it also just shows how these journeys, long journeys, tend to be very emotive in a way. But yeah, thank you for your patience, your support, your kind understanding. And well, I must admit, I didn't come here saying, oh, this is in my pocket. I've always thought that you should never be fully 100% optimistic about different things, and tempering expectations. Well, not in the extreme category of blessed is he who expects nothing from others, for he shall never be disappointed, but rather more of taking it with the flow. And I'm very thankful to all of you. And I believe for a fact that this journey has changed at least my outlook in a lot of respects. So I'm very thankful to EBS, of course, to my supervisors, of course, for keeping up, bearing with my idiosyncrasies. And then, of course, I'm very thankful for the review process that was very exhaustive. And of course, I'm very, very thankful to Regina and to, of course, Sigrid as well. There are reasons it couldn't have really progressed. There were times when I really felt it wasn't going the way I thought it should or would. But thank you once again for this honor. Thank you. Thank you.
Congratulations. Palun.
Thank you.
I'll come next to him as well. And now only him.
Okay, coming.
You know what? You need to step a little bit. Yeah, because we can't. No. There we are. You need to step one more step because you're no. You stay still. Here we are. There we are. Yes. Because otherwise you're hidden. And may I with Katrin's device? Marvelous. I'm trying to get the title and you in the same one. Here we go. Come on, you're done. I'm done. You know what? It's not so easy with everybody's with everybody's eyes going. Are we done?
Champagne, maybe too early for drink.
I think your eyes are open.
Champagne.
Oh, sounds great. I'll give you my photos.
Eyes open, smiles.
Thank you so much.
Thank you.
Maybe from the zipper here. In front of this. Just. So I need to. My place is far. It is for you guys. I wanted to call a vote at 2:20 to be in a vote at 2:30. Can we over time instead? Väike saadet, mis meie poolt ka Tartu suunas oli. No väike saadet siit. Või aitäh sulle töö eest. Seal on kõik ootamist. Kas peab ühe ära ka või?
Tule korraks. Aga mina käin ühe ära ka, seal saab vahetada.